I'm interested in learning more about what I suppose it would have been the state of Texas.
Yeah.
What was their argument throughout all of this, in particular the Supreme Court?
Yeah, great question. Texas, well, I should say first of all, Texas was represented by the Harris County Harris County District Attorney's Office. It was not represented by the State Attorney General, which you would ordinarily have expected to happen where the constitutionality of a state law is questioned. They offered to let the State Attorney General's Office defend the law, but the State Attorney General's Office turned them down. And we don't know why. All I can tell you is that at the time, the State Attorney General was a man named John Cornyn, who was then running for the Republican nomination for the Senate from Texas. And there's some speculation that I can't confirm that it may have been related to that he didn't want to be seen as having this be his #1 issue. On the substantive arguments, I think Texas responded to both the privacy argument that I mentioned earlier and to the equal protection argument. You have to treat everybody more or less the same with the following. On the question about privacy, they said this matter, first of all, has already been decided by the Supreme Court. It was decided in 1986, so we have precedent on our side. Second, we don't just get fundamental rights and privacy rights out of thin air. They come from our history and tradition, and there's no history and tradition of protecting homosexual conduct. And third, since there's no history and tradition of protecting homosexual conduct, we don't need very much of a justification to have this law. And our only justification, said Texas, is that it is the moral view of the people of Texas that we should ban homosexual sodomy. That didn't quite explain why the great moral tradition of Texas allowed you to look with longing eyes upon Fido, but that was the conclusion. On the second part of the argument, the equal protection argument, the state of Texas said that discrimination against gays and lesbians is not a matter of great concern for the Constitution. It is not the kind of classification that we should look at very closely, and we should largely defer to the judgment of states about how they'll classify people based on their sexual orientation. And by the way, homosexuals are not forbidden to have sex. They're simply forbidden to do so with persons of the same sex. They also said that, again, we only need, as a justification for the law, the fact that it's our moral view that this conduct is wrong, and that's all we've ever needed. So that was the basic argument. What was missing from that argument, and what had been present in many other state challenges to these laws around the country for decades, was a claim by the state that we need a sodomy law in order to protect public health from the consequences of homosexual acts. And I asked the Harris County District Attorney why this had been left out, since it had been such a common feature and had been successful in some cases, why this was left out. And he said, #1, we did not want to be seen as being on an anti-gay crusade, and #2, those arguments were silly. Lesbians had lower rates of all of these kinds of things, and by the way, if you want to protect public health, the worst thing you can do is drive behavior underground where you can't educate about it, where people are afraid to come forward. So it was counterproductive. There was no health or medical basis for having such a law, and so the district attorney's office kept it out. That did not leave some of the friends of Texas in amicus briefs. That did not mean they didn't include it. They did make such arguments, but Texas itself, represented by this district attorney's office, would not.